In this lecture, I am going to continue the discussion on the mechanism or the authorities provided under the Industrial Disputes Act for promoting the settlement or adjudication of industrial disputes, either existing or apprehended. We have already discussed, we have already listed out the various authorities provided under the Industrial Disputes Act so as to promote the settlement or the adjudication of industrial disputes, like under Section 3, Works Committee; under Section 4, Conciliation Officer; under Section 5, Board of Conciliation; under Section 6, Court of Enquiry. Just finished the discussion on that in the earlier lecture, where the last one being a Court of Enquiry. The Court of Enquiry is constituted by the appropriate government when it is of the opinion that a certain issue has to be examined in detail, then in which case by notification it may constitute the Court of Enquiry, comprising, if it comprises of only one person, then he'll be proceeding with the enquiry proceedings. If it consists of more than two members, then in which case one of them being the chairman, the Court of Enquiry becomes necessary when the parties to the disputes, although in agreement on all matters, yet on certain issues there may be disagreements. The parties may be on the loggerheads, in which case detailed inquiry or investigation may have to be done so as to collect the the matters on which solution could be found by intervention of this Court of Enquiry. The parties to the disputes may apply either jointly or severally to the government for the purpose of reference to the disputes to the Court of Enquiry. And then if the government satisfied that the party applying for reference is represented by the majority, it shall allow such reference accordingly. And when it is referred to the Court of Enquiry, it's a duty of the Court of Enquiry to submit its report after finishing its investigation or inquiry to the government by whom it is constituted, normally within the period of 6 months from the commencement of its inquiry. It has got the powers subject to the order of reference made by the appropriate government. A member of the Court of Enquiry may, for the purpose of conducting the inquiry into any form of either existing or apprehended industrial disputes, after giving a reasonable notice, may enter the premises occupied by the establishment where the dispute exists. The Court of Enquiry shall have the same powers as are vested in the Civil Court and the Code of Civil Procedure while trying any suit in respect to the matters like enforcement of attendance of any person and examining him on oath, compelling the production of documents or material objects, issuing of commissions for examination of witnesses, and any other matters as may be prescribed. And every such inquiry or investigation by the Court of Enquiry shall be deemed to be a judicial proceedings within the meaning of Section 193 to 228 of Indian Penal Code. The Court of Enquiry also have the discretionary power to grant the costs that are to be paid by the parties to the other. But at its discretion it can decide so. It has the power to determine by and to whom such costs are to be paid and to what extent, and subject to what conditions such costs are to be paid. It may also give necessary direction for the payment of costs on application made to it by the concerned party, which is to be recovered in the same manner as arrears of land revenue. So this is a special provision where when the dispute is referred, if the dispute is dragged, and if it is not a possibility of any amicable settlement, and in which case some solution is expected to be arrived at, but that is not coming on account of the differences exist between the disputing parties, the party either jointly or severally may make an application to the appropriate government, which in turn would refer the matter for detailed inquiry to the court of, by constituting a court of inquiry by notification, and in which case the court of inquiry, while conducting the proceedings, it has got this power to grant such cost at its discretion, cost of the proceedings, who is responsible for the existence of this very proceedings, at its discretion may decide what amount to be paid, to whom to be paid, and how it is to be paid. In case if it is not paid, then the recovery proceedings will be the same as like that of recovery of the arrears of land revenue like. Then a court of inquiry's job is to finally to complete the proceedings within the stipulated time. As I said earlier, even if the stipulated time is not enough, in which case it may make an application to the appropriate government for extension of the time, and appropriate government, for the reasons to be recorded in writing, if it is of the genuine opinion that the time requested for is to be granted, it may accordingly grant. But in case if the dispute happens to be individual disputes connected with any of the matters connected to the industrial dispute, then in which case the time limit may not be 6 months. Time limit is stipulated to be 3 months. Within 3 months, they will have to complete the proceedings and submit the report to the appropriate government for appropriate action. Let us now proceed to Labour Court. The appropriate government under Section 7 of the Industrial Disputes Act may, by notification in the official gazette, constitute one or more labour court for the adjudication of industrial disputes relating to any matter specified in the second schedule, and for performing such other functions as may be assigned to them under this under the Industrial Disputes Act. So it is very important to take note of the Labour Court jurisdiction. Labour Court jurisdiction is normally in respect to the matters contained in second schedule. And what all the matters contained in the second schedule, there are in all 5 schedules attached to the Industrial Disputes Act, and even these schedules are inserted at the end of the Act. Reason being, the very objective of inserting the schedule is to shorten the length of the Act, one, so as to avoid ambiguities or confusions. Therefore, when long list of events, when the long list of items, or when the long list of calculations usually appears to be applicable to any particular act, then normally they are contained in the schedules. And here we have 5 schedules to Industrial Disputes Act, where in the first schedule we will see in the first schedule we will see what may be declared as public utility services, and in the second schedule normally second schedule contains matters which are within the jurisdiction of the Labour Court. In case if any dispute either existing or apprehensive form, if it exists in respect of the matters contained in the second schedule, then it shall be the jurisdiction of the Labour Court to adjudicate upon that. In the third schedule, the matters are contained which are within the jurisdiction of Industrial Tribunal. In the fourth schedule, it is not the jurisdiction of any machinery as such, but it contains the conditions of service for change of which notice is to be given. That is discussed in section 9A, whether employer can bring about a change in the service conditions, and if he can, then what is the procedure, and in respect of what all matters. And they are contained in the fourth schedule attached to the Industrial Disputes Act. And in the fifth schedule, it speaks about when it amounts to unfair labor practice on the part of the employees and on the part of employers. This unfair labor practice, when and what sort of conduct and what sort of activities will amount to unfair labor practice is contained in Schedule 5. So there are in all 5 schedules attached to the Industrial Disputes Act, and the second schedule covers certain matters which are within the jurisdiction of a labor court. And labor court consists of one person only to be appointed by the appropriate government, and the qualification for the person who will be the presiding officer of the labor court. He will be appointed by a notification in the Gazette, and the qualification for a person to be appointed as a presiding officer of a labor court must have any one of the following, namely, he is or has been the judge of the High Court, or a person who for a period of not less than 3 years been the district judge or additional district judge, or he has held any judicial office in India for a period of not less than 7 years, or he has been the presiding officer of a labor court constituted under the Provincial Act or State Act for not less than 5 years. So from any of the above mentioned qualifications, if any person possesses any of the above mentioned qualifications, he shall be eligible for appointment as a presiding officer of the labor court. I repeat those. The qualification prescribed for a person to be appointed as presiding officer by the appropriate government may be any one of the following. 1. He is or has been the judge of the High Court. 2. He has for a period of not less than 3 years been the district judge or additional district judge. 3. He has held any judicial office in India for a period of not less than 7 years. And 4. He has been the presiding officer of a labor court constituted under the State Act or Provincial Act at least for a period of not less than 5 years. From any of the, if a person possesses any of the above qualifications, he may be eligible to be appointed, and it shall be the discretion of the appropriate government to appoint a person holding any of the above mentioned qualification. And when appointed, it is the duty of the labor court to conduct the proceedings in respect of the disputes that is referred to it under section 10 of Industrial Disputes Act by the appropriate government. And such a reference of the disputes to be made by the appropriate government must be by an order in writing, and it should be in good faith, and it should be in respect of the dispute must be in respect of the matters contained in the second schedule. What all matters that are contained in the second schedule in respect of which the labor court has a jurisdiction to adjudicate upon, they are contained in, namely, 1. The propriety or illegality of an order passed by the employer under the Industrial Employment Standing Order Act 1946. 2. The application or interpretation of such standing orders. 3. The discharge or dismissal of the workman, including reinstatement or grant of any relief to the workman wrongfully dismissed. 4th. Withdrawal of any customary concession or privilege. 5. Illegality or otherwise of a strike or lockout. 6. All matters other than those specified in the third schedule. And the 6th one is little broader in nature, but such matters should not be in the third schedule. But there is one proviso. Whatever matters contained in the third schedule, if it is not likely to affect more than 100 workmen, then though such matters in the third schedule are within the jurisdiction of the industrial tribunal, they could also be referred to the labor court. So therefore, the jurisdiction of the labor court is confined in respect to the matters contained in second schedule. You must know what is the meaning of standing order. Standing order is nothing but a legislative power of the employer under the Industrial Employment Standing Orders Act 1946. The employer is empowered under the Industrial Employment Standing Order 1946 to frame standing orders. They are having the force of law, and these standing orders are as good as rules that are applicable to the employees for maintaining the decorum and discipline in the industrial establishment. and there are procedures for drafting of the standing orders and getting its approval from a certified authority, and there are also provisions for its modifications after its approval in case of need. And in case of any dispute, in case of any ambiguity regarding its interpretation, then labor court has got the jurisdiction to examine connected with to examine the legality, the propriety of such an order, and also the correct meaning of the standing order. In respect of these, the labor court will have the jurisdiction. So employer is vested with, but employer is bound to follow the procedure prescribed under the Industrial Employment Standing Orders Act for framing of standing orders. And these standing orders are to ensure the discipline in the industrial establishments to promote industrial peace and harmony. And such standing orders can be framed by the employer by complying with certain procedure in respect to the matters contained in the schedule attached to the Industrial Employment Standing Orders Act. Normally, such would cover the matters like the working hours, the change, the shift, the promotions, the classifications, the discharge or dismissal. That means discipline when it amounts to indiscipline. Such all matters are covered in the schedule to the Industrial Employment Standing Orders Act 1946, in respect of which the employer can frame. Whatever framed thereafterwards certified by the certifying authority, still the employees or the workmen section or the trade union may challenge its propriety or authenticity or legality of the order passed by the employer, in which case they are to be examined and the dispute has to be referred to the labor court. It comes within the jurisdiction of the labor court. Regarding its application and interpretation, if there is any confusion or the dispute prevails, then such matters are also within the jurisdiction of standing orders. Then third one, in case of dismissal of workmen or discharge of workmen, or in the case of a reinstatement of or grant of relief to the workmen wrongfully dismissed, such matters would be dealt with by the labor court. And whatever the customary concession or the privilege that are being offered to the employees as part of their employment as an incentive, if that is withdrawn, then a dispute may be arising. Such a dispute could be referred to the labor court, which are within its jurisdiction. Then in case of strike or lockout, to examine the illegality or otherwise, employer may be contending that, or employee may be contending that the strike or lockout, as the case may be, is illegal, and it cannot be decided by the employer or employee about its illegality. It will be within the purview of labor court. And as I said, such other matters, if they are not covered in the third schedule, could also be within the jurisdiction of labor court. Labor court derive their powers from the statute, and they have to function within the limits imposed by the statute. Their jurisdiction will commence when the dispute is referred by the appropriate government, and appropriate government could refer to the labor court in any dispute if it requires to be adjudicated, since the dispute is with reference to the matters contained in the second schedule. And the labor court, and there may be several cases regarding the termination of employees even before he could attain the age of superannuation, in which case the concerned employee or on behalf of its union could refer the matter to the government for needful action. The government, upon receiving this, if it finds that retiring the employee prior to the attainment of the age of superannuation, then it may consider that it's a fit case to be referred to the labor court, and labor court could proceed with the adjudication. Then regarding the payment of gratuity, then regarding the the relief or the compensation to be payable in case of a strike or lockout, etc. All these matters would come within the purview of labor court as such. Well, let us now proceed to, we will discuss about the limitations on the jurisdiction of labor court when we discuss, when we complete our discussion on the industrial tribunal. Let us proceed now to discuss about industrial tribunal. Under Section 7A of Industrial Disputes Act, the government, appropriate government, by notification in the official gazette, may establish one or more industrial tribunal for adjudication of industrial disputes, either existing or apprehended, if such disputes are relating to the matters specified in the second or third schedule, as the case may be. So this is what the wider jurisdiction of the industrial tribunal. Labor court will have the jurisdiction in respect of the matters contained in the third schedule only when the number of the employees affected by the disputes are not likely to be more than 100. But an industrial tribunal will have the jurisdiction to adjudicate upon the matters which may be specified either in the second or in the third schedule, as the case may be. So compared to the labor court, the industrial tribunal jurisdiction is little wider. Such a tribunal constituted by the government may be for a limited period, or it may also be permanent. The government has the power to constitute a new tribunal if the existing tribunal fails to dispose or failed in its function to dispose of the matter within the specified period. The said industrial tribunal will comprise of one member who shall be the presiding officer and will be appointed by the appropriate government by notification in the official gazette. And who may be appointed as the presiding officer of the industrial tribunal? There are two qualifications. If a person possesses any of those two, he may be considered for the appointment as presiding officer of the industrial tribunal. The first one being he is or has been the judge of the High Court, and second one, he has for a period of at least 3 years held the office as a district judge or additional district judge. From among these two qualifications, if any person possesses any of these two, may be considered for appointment as a presiding officer of industrial tribunal, and government by notification may appoint. The function and duties of industrial tribunal is very much like that of a court while discharging its judicial functions. Although industrial tribunal is not exactly a court, but its functions are similar to that. The powers of the industrial tribunal are different from those of an ordinary civil court. The proceedings before the industrial tribunal are quasi-judicial proceedings in nature, with all the attributes of an ordinary court of justice. The appropriate government, after constituting the industrial tribunal, may, in the exercise of the power conferred upon it under Section 10, it may pass an order in writing after framing an opinion in good faith for making the reference of such a dispute. Normally, such matters are covered under the third schedule, and it is enumerated as under. So, jurisdiction of the industrial tribunal is covered under third schedule. It can also exercise its jurisdiction in respect of the matters contained in the second schedule, and the matters in the third schedule of the third schedule to the Industrial Disputes Act 1947 is enumerated as under: 1. Wages, including the period and mode of payment. 2. Compensatory and other allowances. 3. Hours of work and rest intervals. 4. Leave with wages and holidays. 5. Bonus, provident fund, gratuity. 6. Shift working other than in accordance with the standing orders. 7. Classification of the employees by their grades. 8. Rules of discipline. 9. Retrenchment of the workmen and closure of the establishment. And last one, any other matters that may be prescribed by the legislature from time to time, by the appropriate government from time to time. The jurisdiction of the Industrial Tribunal is very much limited for the contents covered under Schedule 3. The tribunal cannot exceed in its authority by going beyond the subjects enumerated therein while adjudicating the disputes referred to it by the government. That is what in the normal circumstances. It is very clear that it is the responsibility of the government to frame the order of reference carefully so that the issues that are to be decided by the tribunal are clearly stated in the order of references without any ambiguity or without any scope of controversy. A government, if it makes any hasty references while referring the disputes to the adjudicating authority, if it displays the casual attitude, then it will prolong the litigation before the industrial tribunal or even before the labor court as such. So that this must be avoided, and the government must be extremely cautious and scrupulous enough while making the reference of the disputes in respect of any of the matters contained in the third schedule. First of all, it should frame an opinion whether the dispute deserves to be referred to the industrial tribunal or whether it could be resolved by other means. When it could be resolved by alternative means, then it shall go for that alternative means like a conciliation officer or board of conciliation, like that. But when it is inevitable that that the dispute deserves to be referred to, since the matter is contained within the jurisdiction of the industrial tribunal, then it may do so by making an order of reference. If an industrial dispute that is referred for adjudication before the tribunal, then it shall hold the proceedings in such a manner so as to dispose of the proceedings expeditiously. When we say expeditiously, means it all depends upon the nature of the disputes and the consequences. The dispute, after the dispute has arisen, how it affected the industrial environment. All these factors should be looked into, and accordingly it shall dispose of the proceedings in effective manner. Then, while exercising its authority, it should always be cautious to examine in length the cause of the dispute in respect of that matter and what best can be done. So it has got all the powers of a civil court to in the course of conducting of the proceedings. It shall refer, and when the proceedings are concluded, it shall refer its findings by way of submission of award within the specified time period, and normally the time limit will not be set, but the industrial tribunal from the date of reference after commencing the adjudicated proceedings without any unreasonable delay, it shall conduct the proceedings, commence the proceedings, conduct the proceedings, and conclude the proceedings. Upon the conclusion, it shall submit the award for the government for publication, and the government shall publish that award within the period of 30 days from the date of its receipt. And in the course of exercising its powers, in the course of conducting its proceedings, the presiding officer of the tribunal, for the purpose of inquiry into any existing or apprehended industrial dispute, after giving reasonable notice, can enter into the premises occupied by the establishment. It enjoys the same power, as I said, just like that of a civil court in conducting the proceedings, like enforcement of attendance of any person for examination or compelling the production of any documents, and tribunal in the course of the proceedings for its own assistance, it can appoint one or more assessors having special knowledge to advise and assist in expeditious continuation of the proceedings in an expeditious manner and to arrive at an effective findings. The tribunal has the power to award costs against such party and the conditions under which the party is entitled to such costs. Let us now proceed to discuss about the limitations on the jurisdiction of the tribunals and the labor court. The limitations could be either imposed by the jurisdiction of labor court, and the jurisdiction of the industrial tribunal is not wide enough. Its limitations can be classified into the following four categories, like limitations imposed by the Industrial Disputes Act, limitations imposed by other industrial laws, limitation imposed by any other statute, and limitations imposed by the terms of reference under Section 10 of Industrial Disputes Act. The terms of the reference is being made by the appropriate government for adjudication of any disputes either to the labor court or the tribunal. Then the labor court or the tribunal, as the case may be, they are bound by such terms of reference, and while conducting the proceedings, they must confine their adjudicatory proceedings in respect of those matters, in respect of the terms of reference, and they shall not go ultra vires. And in case if they go ultra vires, the entire adjudicatory proceedings of the labor court or the industrial tribunal could be challenged, since it has gone beyond the terms of reference. So therefore, there are some limitations on the jurisdiction of a labor court or the industrial tribunal. As I said, limitations imposed by the ID Act 1947, or limitation imposed by any other industrial law, limitation imposed by any statute, and the limitation imposed by the order of reference. Under what circumstances the reference could be reference made by the appropriate government under Section 10 could be challenged? That we will discuss when we take up for the discussion on the power of the appropriate government in making the order of reference under Section 10 of the Industrial Disputes Act. Now let us proceed to Section 7B, where the central government, let us not use the term appropriate government, where central government under Section 7B of the Industrial Disputes Act has got the power to constitute a national tribunal when the dispute is of such a nature that it is affecting the questions of national importance, or industrial dispute is of such a nature that it is affecting the interest of two or more states, in which case it deserves to be referred to the national tribunal, as the industrial tribunal of one or the other state will not be the appropriate one, as it may be biased, in which case the reference to the reference will be made by the central government to the national tribunal only. So what all the matters that could be referred to the national tribunal, and who could be appointed as the presiding officer of the national tribunal? Any person, for a person to be the presiding officer of the national tribunal, he must have the qualification like either he is or he has been the judge of the High Court. Only this qualification is allowed for a person to be appointed as the presiding officer of the national tribunal. And under Section B, the appropriate government being the central government may refer any industrial dispute concerning any industry, in respect of which central government is always the appropriate government. It may pass an order for making the reference of the disputes to national tribunal when it is of the opinion, when in the opinion of the central government, the dispute involves the questions of national importance, or the industrial dispute either in the existing form or in the apprehensive form is affecting the interest of two or more states, or an industrial disputes if the central government is of the opinion that the industrial dispute deserves to be adjudicated upon by the national tribunal, it may pass an order in writing for making the reference thereof to national tribunal, and the national tribunal upon the dispute being referred to it, it may proceed to adjudicate upon the dispute as contained in the order of reference without any unreasonable delay, and it shall submit its award to the central government for publication. Central government would in turn publish it within a period of 30 days. As it is stated, what all matters in respect of which dispute is existing, dispute either in the existing or apprehensive form, what all such matters could be referred to the National Tribunal. There is no such listing of the matters as such. The matters may be connected with either in the second schedule or in the third schedule. But in respect of such matters, if any dispute exists, if such a dispute affects the interest of the nation, or if it involves questions of national importance, or it is affecting the interest of two or more states, or if the central government has come to a conclusion that even though the matters are contained in, even though the dispute is in respect of a matter contained in the second or third schedule, but the central government is of the opinion that it is best to be referred to the National Tribunal for Education, then it may pass accordingly for making the reference thereof for adjudication in respect of that particular dispute. The powers and duties of the National Tribunal, as I said, powers and duties of the National Tribunal will commence when the dispute is referred to it for adjudication. And what kind of dispute, as I said, it must be involving questions of national importance or affecting the interest of two or more states, like that. Upon the dispute being referred to it, the National Tribunal shall commence the proceedings, conduct the proceedings. In the course of conducting the proceedings, it assumes the powers of a civil court like, and conclude the proceedings and submit the award to the central government as soon as possible, without any unreasonable delay. Though there is no stipulation of time for the central government to conclude the proceedings, but in the normal practice, the National Tribunal is expected to hold the proceedings expeditiously and shall, as soon as possible, submit its award after conclusion of the proceedings to the central government. Central government, from the date of its receipt within 30 days, shall publish the same, and then it will be in operation for a period of 1 year. A person who will be disqualified to be a presiding officer of the labor court or tribunal or national tribunal if he is not an independent person, or if he has attained the age of 65 years. But this speaks about the disqualification. Therefore, if a person is disqualified, if he has some interest in the industrial establishment where the dispute is either in the dispute of either form is existing, or if he has completed the age of 65 years, in which case he is not competent to be, he is not qualified to be appointed as a presiding officer of the labor court or tribunal or national tribunal. And then we have got under section 9C, that is regarding constitution of grievance settlement agency. The appropriate government, it is an obligation under section 9C. It's an obligation of the employer to constitute one or more grievance redressal agency, where in an establishment employer employing 20 or more workmen, then in which case it is mandatory on the part of the employer to constitute one or more grievance redressal agency, which comprising of 6 members in equal proportion from employer and employee side. That means to say that it will comprise of 3 members each from employer and employees. when the grievance settlement agency is constituted by the employer, such grievance redressal agency in day-to-day affairs of the industrial establishment, if any differences or if any dispute exists connected with the industrial matters, it is like employment, non-employment, terms of employment or conditions of employment, in which case the employer may refer the matter to the grievance settlement agency or a grievance redressal agency. The grievance redressal agency shall conduct the proceedings and the time stipulated under the provisions of section 9C is 30 days. Within 30 days, as within the stipulated 30 days, the grievance redressal agency shall conclude the proceedings and submit its findings to the employer. It is the employer who is going to decide. One more. In case if the action of the grievance redressal agency is not satisfactory, they may appeal to the employer within the period of 30 days. That is another. Appealing to the employer against the findings of the grievance settlement agency. But whether it can be a fruitful one, you can only imagine. Grievance redressal agency and its functioning is not very well appreciated. The reason, the parties to the disputes themselves being the representatives, their own representatives are there in the grievance redressal agency in equal numbers. They conduct the proceedings like a conciliation or mediation, something like that. Their main objective is to find some sort of a solution to redress the grievances that may be occurring in day-to-day affairs of the establishment. Though the time limit stipulated for them is 30 days to finish off the proceedings, it can be extended by the employer. And upon conclusion of the proceedings, if any of the if any of the party to the dispute is not satisfied with the findings, it may appeal to the employer within a period of 30 days as such. The veracity of this particular machinery is little less effective. Reason, it gives an edge to the employer in respect of the matters which is referred to it for redressal, and the workers may not be appreciating for various reasons, either they themselves being inferior in the position, and every power is given to the the dominant position, or the dominant authority is being still with that of the employer. The employer, if it is convenient for his industrial, if the employer is of the opinion that findings of the grievance redressal machinery, if it is going to beneficial to his interest, then he would implement the same. If it is not going to be beneficial to his interest, if it is going to be a hurdle in the course of his industrial establishment, then he may not value them at all. So this being the case, the success in the working of grievance redressal agency will always be a question mark. But it is provided to find a sort of a quick redressal to the differences that may be cropping up in the course of the employment operations. In case if that dispute, either in the existing form or apprehensive form, arises, then it could be in such double quick time could be redressed through the mechanism of redressal agency, grievance redressal agency. But as I said earlier, grievance redressal agency comprising equal number of representatives in maximum 3 each, minimum 1 each. it will have maximum of 6 members, where the final authority to implement the decision vests with that of the employer. And if the employer's action is not if the findings of the grievance redressal authority is not satisfactory, then the parties to the disputes not happy or not satisfied with that may appeal to the employer to find a redressal. And there is one more mechanism provided under the Industrial Disputes Act, that is under Section 10A. Section 10A is talking about the arbitration. Under what circumstances Section 10A provides for the voluntary reference of the disputes to arbitration by the parties, as and when the dispute is arisen, then in which case the parties to the disputes by their agreement may voluntarily proceed to refer the disputes by appointing arbitrator or arbitrators, as the case may be, by a written agreement. And the requirements for such a reference to arbitrator by the parties are the following. 1. There should be either existing or apprehended industrial disputes. 2. The reference should be made by written agreement between the parties before the dispute has been referred to any of the authorities under Section 10 of the Industrial Disputes Act. Third one, the name or names of the person or persons to be appointed as arbitrator must be specified in the arbitration agreement. And even such persons who have agreed to act as arbitrators must be consenting to their appointment as such. So if the above mentioned three qualifications are there, if the above mentioned three conditions are present, then the reference to the arbitrator will be good. And when the parties decides voluntarily in the case where dispute exists or apprehended, then they may proceed for appointment of arbitrators. The relevant Section 10A lays down that the parties are free to appoint any number of arbitrators. Earlier there was no provision to resolve the matter if the arbitrators were equally divided, and under such circumstances parties has to make a reference to another arbitrator again, or to move to the government for making the reference under Section 10. But the insertion of subsection 1A to Section 10A has removed all this difficulty, which lays down that for the appointment of an umpire, which provides for an appointment of umpire in the case where the arbitrators in even number are divided, and such an umpire could be appointed, and whose opinions would prevail in the case of such equal division of the arbitrators' findings. The arbitration agreement should be in the form as may be prescribed under the Industrial Disputes Rules 1957. It makes it obligatory upon the government to publish the arbitration agreement in the official gazette within 1 month from the date on which the arbitration agreement has been furnished by the parties to the disputes to the appropriate government. And it is the duty of the arbitration it is the duty of the arbitrators, after the dispute being referred by the parties mutually, it shall be the duty of the arbitrators to commence the proceedings. And once the arbitration proceedings are commenced, then they will proceed to conduct the proceedings. And as far as the you know, the proceedings under Section 10A of the Act, where the dispute has been referred to the arbitrators, has essential features of a statutory arbitration under Section 10 of the Act. Under the relevant article of the Constitution of India, that is Article 227, the High Court has the power of superintendence over the arbitrators who function under Section 10A of the Industrial Disputes Act. Therefore, the orders passed by such an arbitrator who acts as a quasi-judicial body and their proceedings are quasi-judicial in nature, they are capable of being corrected by a writ of certiorari, provided, of course, there is an error of law apparent on the face of record, which is probably one of the grounds for the issue of one of the most important grounds for the issue of writ of certiorari. The arbitrators appointed under Section 10A of the Industrial Disputes Act have the power in the course of the proceedings, have all the powers just like that of the civil court, in case if it is necessary to conduct the proceedings, and they have even the power to bind even those who are not parties to the reference or the agreement, and the whole exercise of the powers by the arbitrators under Section 10A, as well as the under Section 10A, I mean to say that the arbitrators under Section 10A of the Industrial Disputes Act has the power to bind even those who are not parties to the reference, or who are not the parties to the agreement which is responsible for making the reference or dispute to arbitrators. And the whole exercise of exercise under Section 10A as well as the source of the force of the award on publication derives from the statute. There may be cases that could be referred as far as the reference of the disputes made to arbitration, like Gujarat Steel Tubes Limited versus Gujarat Steel Tubes Mazdoor Sabha, where Supreme Court observed that the arbitrator under Section 10A has the power to bind even those who are not parties to the reference or who are not parties to the agreement, and the whole exercise under Section 10A, the whole exercise under Section 10A as well as the source of the force of the award on publication derived from the statute. Section 10A and Section 10 of the Industrial Disputes Act provided alternative remedy. The decision of the arbitrator under Section 10A is quasi-judicial decision, and therefore it is liable to be quashed if the reasons are not given in support of the findings of the arbitrator. So, these are all the machineries that are provided under the Industrial Disputes Act for, as I said, for resolving the disputes through any of the methods like agreement or settlement or adjudication or arbitration. The final one being rests with the discretion of the parties. If they want the dispute existing in respect of any of the matters connected with the terms of employment, or in the case of non-employment, or in the case of employment, or in the case of conditions of employment, in case if any dispute is there, then the parties by their agreement may proceed to refer the dispute to arbitrator, one or more arbitrators, and the provision is even there in case if two or more arbitrators are there, and if they are equally divided, in which case there is a provision for the appointment of an umpire for the purpose of arriving at a final finding. And umpires, in which case the umpire decision is like a third umpire. Umpire decision is final. That's it. And in the next lecture, we will proceed to discuss on the powers. The power of the appropriate government in making the order of reference under Section 10. And even we will discuss with reference to Section 9A, that is employer's power to bring about change in the service conditions in respect to the matters contained in the fourth schedule. We will discuss in the next lecture. Thank you.